Okay, I'm now going to share. All right, question 26. Go ahead.
The defendant has moved to quash the indictment on the ground of double jeopardy. Well, okay. How should the court proceed? A, grant the motion because the dismissal of the first charge on the merits, whether correct or incorrect, bars any further prosecution of the first charge? No. B, grant the motion unless the prosecution has evidence that was not presented in the first case. In the first case, I'm going to strike it because if the case has already been tried and there's more evidence, it doesn't matter. C, deny the motion because the defendant has not yet been in jeopardy of conviction on the attempted murder charge. I'm going to leave that. D, deny the motion because the protection of double jeopardy clause does not come in to play until there has been a conviction or an acquittal. No, I learned that double jeopardy attaches once the jury is impaneled. So I'm going to strike that. I'm going to leave C. A defendant was charged with attempted murder. At the preliminary hearing, the presiding judge heard the testimony of four prosecution witnesses and found that the prosecution had failed to establish probable cause that the defendant had committed any offense. Accordingly, he dismissed the charge. The prosecution then called the same four witnesses before a grand jury. The grand jury indicted the same defendant for attempted murder. The defendant has moved to quash the indictment on the ground of double jeopardy. How should the court proceed? C, deny the motion because the defendant has not yet been in jeopardy of conviction on the attempted murder charge. I'm going to stick with D, deny. Double jeopardy doesn't, they're at a preliminary stage, an indictment, so he hasn't been charged technically by the judge, but the grand jury can charge him. So I'm going to stick with C.
Okay, there's a couple that you didn't say what I teach you. First, you know for sure that is wrong. You need to strike it twice, and I think D is the one that you say for sure because you have learned that, right? So if you strike it twice, meaning there's no way you're going to read D, okay? So you know it for sure is wrong, okay? And then another thing that I saw that you forgot is to circle or underline the grand jury, okay? So you know the grand jury is way beginning of the game. So it's not even, it's not even a question whether it's attached or not. Only when a jury is sworn in and at the bench, the jury panel. You see it? So therefore, when you see grand jury stuff, and what you know is double jeopardy. So when you read the word double jeopardy, you should say, well, when is it attached in your head? Right? So you see grand jury and you say double jury, that right there tell you that is cannot be granted. The motion to suppress cannot be granted because grand jury stuff is way ahead of time, of the timeline. So cannot, right? So here's grant and grant is out. So even faster now, right? Even faster. So C.
C, correct. For double jeopardy purposes, jeopardy does not attach until trial, when the jury is sworn in, or in a bench trial when the first witness is sworn in.
So write that down. So here we know the law about the bench trial. So the bench trial, the bench trial is when a first witness is sworn. So that's when the that's when double jeopardy attached.
Got it.
Very good. I think we kill it.
Alleg-